It's been almost 2 decades since we started our journey to educate and help you take action so you may better manage your financial future. Our goal is to help you accomplish your life's purpose. This podcast reveals financial tips, strategies, and insights that will help you to set your financial goals and guide you along the way. This is Managing Your Financial Future, brought to you by the advisors at Lucia Capital Group. Well, hello. Welcome back to another episode, another installment, I guess, of Managing Your Financial Future. So nice to have everybody back here with us. Season 6, Episode 2 now. Last week, we talked about I guess it was complicated. We tried to simplify Social Security. It was technical.
We tried to simplify the taxability of Social Security.
Yes. Now what we did was we wound up with a number of questions from people who were asking us, not that they didn't understand it so much, but they were concerned that their Social Security may fall into the taxable column. Yeah. So once again, I just remind folks that it's a good idea to talk to your financial advisor about that. Somebody like Professor Plum, who is a certified financial planner professional, and I'll reclassify myself as the host of this podcast and the moderator because that's what I am. But I do talk to you, and you talk to clients and people all the time, Professor Plum, about various aspects of their planning. Social Security taxation is one. Sometimes withdrawal strategies is another. Buckets, things like that we like to talk about. And here's one that came up, and you did a Lucia Capital Group Weekly not too long ago, I think, on this very topic. But it has to do with something we don't talk about a lot on this podcast, and that is overall estate planning, but naming your beneficiaries.
Well, beneficiaries can be very important, and I unfortunately took a question a couple of weeks ago now from somebody who they were wondering why something was happening, and at first it didn't make sense to me because they said my uncle had a trust, a living trust, and he had a non-qualified annuity in the living trust. The owner was the living trust. He was the annuitant. The trust was the owner of it. He unfortunately passed away, and the proceeds, about $280,000, did not go to the trust. They went to probate. They went into the estate. And I was thinking, wait a minute, it was owned by the trust. If you went through the process, the paperwork, the hassle of naming the trust as the owner rather than just yourself, who was named as a beneficiary? And the insurance company said nobody.
They didn't put a beneficiary on this.
They did not name a beneficiary. I think they just assumed that because the trust was the owner, that the beneficiary would be the number. But the insurance company's default is that if no beneficiary is named, this particular, not everyone works this way, but this one did, unfortunately. If no beneficiary is actually named, it will default to the estate. So now this money is being paid to the estate, not to the trust. Why is that an issue? Because it has to go through probate.
Yeah, and
probate can be time-consuming. It is public, and it can be expensive.
In many cases, it is expensive. We talk about things like beneficiaries. I'm going to keep this fairly.
It's important to name beneficiaries. If you have anything that allows for a beneficiary, very simply, a life insurance policy, an annuity, an IRA, 401k, tax-deferred account, something of that nature.
What about your home, your primary residence?
Well, homes are a little different in that real estate can have basically a beneficiary, a deed designation. Every state in the union does allow for a transfer on death type of it's not called a TOD, but it's a beneficiary deed type thing that says if I die, then it goes to this person. But you have to. It's not automatic. It's something you have to do. So it's like adding a beneficiary to real property. If you have a non-IRA account, just a brokerage account at the local brokerage company, you can add a TOD or a POD, depending upon whether it's a financial institution like a brokerage account or a bank. TOD stands for transfer on death. POD stands for payable on death. They're the same thing, but different types of institutions use them differently. I mean, so one, like banks use POD.
But
it's the same idea. Yeah. OD.
Yeah. So
Olivia de Havilland.
Officer of the day. If I have a life insurance policy, in most cases, when you fill that out and you get the life insurance policy, they're going to ask who's the beneficiary.
You should always be looking at if you're buying a life insurance policy, why are you buying it? What is the purpose of the life insurance? Is it to provide for a surviving spouse? Well, assuming the surviving spouse is not a crazy person, just name that surviving spouse as the beneficiary. If it's to provide for the kids, that are old enough. Now, if the kids are younger, and this is where it comes into play. Are we looking to give this money directly to the beneficiary, or are we looking to control it for a period of time until the beneficiary becomes of age, or until the beneficiary shows that they are financially capable? And that could be at any age, maybe never an age, of handling it. And so that kind of tells us whether or not we should be naming that individually directly as a beneficiary, or maybe have a trust which then can control the asset for that beneficiary. But control is the issue. If control is important, then you want to have something that controls it other than that person, that individual that you're leaving it to.
And is this where
a living trust or some kind of trust comes into play?
The trust is really there to allow that control. Is that correct?
Well, the trust is twofold. One of them is to avoid probate. That's one of the main purposes for a living trust, avoiding probate on assets that typically don't have beneficiary assignments. Normally real estate and other things like that, your personal brokerage accounts. But you can then control is also another big issue. Avoiding probate and control. Those are the two big reasons for having living trusts. Used to be that we had estate planning reasons. We don't have them as much, but now it's about control and avoiding probate. And so
if they bring the estate taxes back down, we
may see it again.
We may come back to the old AB trust date.
And there may still be a reason for an AB trust, but it's from the control issue now.
Yeah, so we talk about control, we talk about avoiding probate. Now, for a lot of people, they don't really understand how any of this stuff works. They have a life insurance policy, maybe their spouse, if they're married, that'll be the beneficiary, and the primary, and the secondary or contingent beneficiaries might be the kids if they have kids. They may have some brokerage accounts. Hopefully they've filled out some sort of beneficiary designation on that, or TOD, POD type of thing with their bank accounts. But what about all the other stuff that people own? I mean, people say, well, heck, I've got all this furniture. What do I do with this? Is this stuff?
Well, unfortunately, you can't put a TOD, POD beneficiary title. I guess you could take a sticky and put it on the back of the couch with somebody's name.
But we talk about trusts owning things.
But a trust can only own things technically that have a title, that you can title in the name of, your pink slip from your car or something. And your couches, there's no title to it.
Yeah.
So normally those are handled, and normally they don't add up to hundreds of thousands of dollars. Normally, maybe there are some people out there that have furniture that collectible and things like that. But like if you have a art collection, you have a way of identifying it and owning it in the trust. You say that is owned by the trust.
But you have just what's called a pour over will type thing.
Right, the will. But so for assets, like in my household, we've got a little bit of furniture, nothing that adds up to that much. But over the years, I think that every project I've ever taken on used to start with a trip to Sears. You had to buy some new tools.
Of course, Craftsman.
Or Snap-on or some of the other ones, like if I could afford them. So I've got quite an array of tools that I probably will never use again.
Of course you won't.
But my son is looking at my two son-in-laws are saying, you know what? This will be interesting. So those will be outlined.
But those kinds of things don't go into a trust because there's no title to it.
Yeah, they go through, the will say, so-and-so gets this, so-and-so gets that, so-and-so gets this of these assets of a personal nature. The tools, the furniture, the jewelry. We don't have any millions of dollars worth of jewelry, but, this ring, that necklace, this thing will go to so-and-so and so-and-so.
So you still
that goes through the will.
You still have to go through all your assets when you're setting up a will.
Or you just say...
Fight over it?
Just say, let the kids deal with it.
Which I think is what most people do.
My wife did, she had a friend of hers, his father passed away, and her friend was dealing with settling the estate. And there were some other things that made her aware of the fact that one of us, probably me most likely, we could leave this earth at some point. And she's like, well, what do we do? We've got some nice china from both my sets of grandparents and from my mom. So we've got 3 sets of china that are really cool. And so we were starting, she was like, okay, kids, do any of you want, is there something specific that you want? If something happened to us, are there assets that you would like, to China, whatever. My daughter said she wanted my car. And I was like, wait a minute. I'm hoping to have multiple cars between now and when I pass, so don't say you want that one. But
yeah, and it could still be 15 years, and that thing's a piece of junk.
Yeah, and you can have it then. But yeah, we were talking more about personal items, like specifically the China, because we do have some nice
things
China.
Like personal items. Does that all go through? It's in a will. Does it have to go through probate?
It's generally the things that if you've done it correctly with the trust, you've only got a small amount of value. They may have a great deal of emotional value, but it doesn't have a significant, you're not talking about $250,000 or $500,000 of personal assets that are flowing through the trust. So the estate has a fairly small value, and it doesn't take very much to get that done.
Okay, so that's not necessarily a problem. I talked for a little bit ago about beneficiaries.
Beneficiaries
That's kind of what
are key.
I want to talk about here. Beneficiaries being the key. You have things like primary beneficiaries. You have
and contingents, because what happens if that primary beneficiary is gone before you are? Maybe they're with you in the car when that proverbial Mack truck finds you. And then now, if there's
you're both gone.
Now you're both gone, and it goes to the estate.
You can have, as I know, and you know, more than one primary. So if I have
primary
three kids,
is a class.
Yeah. So if I have 3 kids and I have a $900,000 life insurance policy on me,
make the math easy here.
Make it a lot easier. I can name 3 primary beneficiaries.
Oh yeah.
And it may be a good idea to do that, depending on whether if I don't care. If
I have 3 kids. Now, they're my contingents because my spouse is my primary. But if something were to happen to my wife and I, the 3 kids, there's no primary beneficiary left. The contingents now step up to the primary role, and there are 3 of them, and they get a third of whatever it is.
And that's been designated. That
on the life insurance and the IRAs and the 401ks and all the accounts that have beneficiary assignments, they're designated 33 1/3 each. Although one of them wouldn't let me do fractions or decimals, so my son's going to have to, explain
to 33 cents or something.
Explain to the girls, the 2 daughters, that he got 1% more than they did on the life insurance or whatever it was.
Dad always loved me best.
No, he was just the oldest.
I get it. Trusts. You should. We talk about.
Well, we want to coordinate beneficiaries with trusts.
Yeah. So how does that work? And what's a good way to do that?
Well, you've got different types of assets. A lot of the assets, your real estate and things like that, instead of having that beneficiary deed we talked about, own it in the trust. And then when you pass away, that tells the trust that this is what now happens to the asset. But because the owner is the trust, the owner didn't die. So that asset is not going into probate anymore. Now, there's some administrative issues that have to go through, but it's nowhere near as bad as probate. And then the trustee handles it according to the wishes of the individual who passed away, and there's no probate. And so you then distribute it according to the trust wishes.
It's a lot cleaner. What sort of assets would you normally recommend go into a trust? I know we talked
almost
a little about
everything you have. Although, like your everyday banking, checking account that you don't keep a lot of money in, or you shouldn't keep a lot of money in because it's paying nothing. Absolutely. I mean, bank accounts are paying pretty much nothing.
Yeah.
But checking accounts, for the most part, are usually paying absolutely nothing. And so you keep enough in there for a month or two's worth of expenses, but you keep your real money in a bank account or something or your brokerage accounts that actually earn some money. So your bigger savings accounts, your brokerage accounts and all that should be in the name of the trust. Your day-to-day checking account many times, because you don't like signing John Dean trustee on everything. You just sign John Dean on the checks. Although we don't write very many checks anymore.
We don't write checks at all. I've got the same checks I've had for about 2 years.
So, most assets are going to be in the title of the trust. Depending upon the cars you have, if you've got collector cars or nice expensive cars, they could be in the name of the trust. If you've got a 78 Yugo, you
have to be an 85 is when they first appeared.
Is that when they first appeared? I don't even know.
I had a 78 Caprice Classic once.
That's a big car.
It was a nice big white car with a hood ornament on it. And bench seats.
I'm going to ask you a question that you're probably... Did it have the big 454 in it?
No, I don't know what a 454 is.
I was going to say, I didn't...
If that means it went really fast, no.
Did it guzzle the gas?
Oh, yeah.
It probably did.
Oh, yeah. It had a little gauge. Every time you push on the accelerator, it would show you the fuel economy going down. That's all it could do.
My friend had a Caprice Classic, a big 4-door, not station wagon, but
it was a sedan.
Sedan. I think it was huge, but it had this big motor in it, And he could get it going pretty quick, but it did suck the gas.
Oh, absolutely, it did. But if you have just your regular cars, you were about to say, if you have
you could just name them in your own name, because it's not going to. It'll go through probate, but probably nobody in your family wants it anyway.
Well, that's probably true.
But anything you don't want to have a hassle with, you can put in the name of the trust.
So when you're setting up a trust, we talked about control.
This is the hardest part about creating a trust, is control. If you're actually setting up control, you don't want, you got 3 kids and one of them just cannot handle money, or is dangerous with money, or dangerous to themselves. That's unfortunately an issue a lot of times. Who do you name as trustee? The trust naming of the success. When I'm gone, my wife is gone. Who do we name as trustee? You want somebody that can stand up to the beneficiaries that you're trying to put control over.
Well, so let's say I had 3 kids and I had a $900,000 life insurance policy for my wife. Well, let's say she passed away before I did, and I still have this, and I want this to go to my kids. But 2 of them, let's say I trust, and 1 I don't. Okay? Let's just set that up hypothetically. I could set up the trust where the 2 that I think will be okay with the money will receive, when I die, each get $300,000. But the third one that I don't trust, I can have the trust hold on to that. Is that right? Hold on to that money, and the trustee will dole that out according to my whatever I.
Who's the beneficiary of the life insurance?
Well, that's what I'm asking.
Did you name the 3 kids the beneficiary of the life insurance?
Well, that's where I want you to go with it.
This is what I talked about, coordinating your estate plan. If you name the 3 kids as the beneficiaries individually, but your wishes are that the share that goes to the one child who's not been good with money, who will probably blow it in the first couple of days, the trust is set up to handle that money for them. Well, guess what? You just wasted a bunch of time and money, because that trust will never see the money, because it's going to go directly to the beneficiary that you named.
So what I should have done was name the trust,
or name the 2 kids individually and name the trust as the third, and have that trust only be for the benefit of that one child.
And that trust will dole out money as I see fit.
Well, as you've specified in writing, as now the successor trustee is in charge of. But if you named, one of the siblings who can't say no to their little brother.
Let's say I named my brother as a trustee.
And he's always had a soft spot for these kids, especially this one that's always had an issue.
Right.
And he can't say no. If that the one that, oh, come on, Uncle, I can't think of the name. Uncle Brian.
Yeah.
Uncle Brian, come on. Dad really wanted me to be able to have some money here.
I'm melting. Yes. Oh, sure. Here you go.
Oh, yeah. Okay. Well, the money's gone. There's no control.
One of the more important aspects of when you're setting up a trust is to have a trustee. Who should you look for in the trustee?
Somebody can say no. It depends. If you're saying control.
Is it good to have a totally, a stranger do it? Somebody that
it's expensive, but it may be worthwhile. I mean, obviously, if you're hiring an outside trust company or somebody else to do it, you're going to pay them. People don't do this kind of work for free.
Yeah.
And it's not something I'm applying for. We can't do it. So I'm just saying, people get paid for doing this kind of work. And so you have to weigh, how much control do I want compared to how much I'm going to pay to get that control.
But this is one of the benefits of owning a trust, which is that there's
the potential for control. The biggest issue is the avoidance of probate in my mind. But there are people that really need to control the assets for the beneficiaries.
So if I've got brokerage accounts, and if I've got bank accounts, and I've got life insurance
the bigger problem with that is, what about IRAs? Who do you name as the beneficiary of your IRA?
Or 401k or whatever.
Tax-deferred accounts.
Yeah.
And a lot of people just name the trust for everything. Well, unfortunately, the way trusts handle beneficiaries depends on how that brokerage company, that IRA, is set up. Some of them, you can't split. If I have a trust as a beneficiary and I name my 3 kids as beneficiaries of the trust, well, the trust is now the beneficiary of the IRA. Some trust companies, some IRA companies allow you to split it into 3 different IRAs, one for beneficiary IRAs, one for each of the individuals, and then they're all independent of each other. Others, there's only one IRA. It's still the trust IRA. So if there's $900,000, and you have 3 kids, well, they each get $300,000, but one of them needs $100,000 right away for a down payment on the house. The other ones don't want to pay the taxes. It's going to be treated all the same. So it's a harder issue when it's done that way. So normally, if no control is necessary, if no control is desired, it's cleaner for the beneficiaries to be named directly and not have the trust in the way there. So it's avoiding probate either way.
All right. So if I have a 401k or IRA or whatever it is, I either better have a beneficiary designation, primary and a contingent beneficiary, or I better name the trust.
Well, that's still a beneficiary designation.
Well, yeah, I better do one or the other, because if I do nothing,
it's going to the estate.
Everything is going to go to the estate. Now, let's say I do nothing, but I have a spouse, and I pass away. Is the spouse generally going to be the one who receives that?
Yes. I mean, now it passes by the laws of the state. Now, assuming this is your first spouse and long-term spouse, then it's not an issue. Where the problems come in is where this is not the first spouse. Maybe you've only been married for a couple of weeks, and you still have the old spouse, ex-spouse, listed as your beneficiary. Now you got a fight on your hands. Well, you don't. You're dead. But
well, is this where things like probate come into play?
This is just
a court.
The new law has the rights to it, or the new spouse. So you'd have to, because you're now married, and because the new spouse is deemed to be the beneficiary.
Things like 401ks, your company
401ks and IRAs,
if I do nothing, the spouse currently,
they can easily step into it.
Meaning what?
Even if you don't name them, they can petition to have it done. Now, they have to do something about it, but it's not outrageously difficult to have it done.
A spouse is generally, by default,
I won't say by default. Some of them will just do default to the estate, and then the estate has to name the spouse as the beneficiary.
Really?
Yeah.
See, I was under the impression that the 401k, if I set it up, that the default beneficiary is my spouse.
I think every state may be a little bit different, but and I'm not an attorney, so I'm not giving you any kind of legal opinion in this area. But it's my understanding that the estate becomes the beneficiary, and it's very easy at that point for the estate to go through the probate process and name. You have up until September 31st of the year following the year of death to name beneficiaries.
That's great, because September 31st never happens.
Of the year September 30th, excuse me. Yeah, so I had to get back to my knuckles.
That's great. September 31st. Wow.
You have 9 months to name the,
yeah, I got you. I know what you mean.
But you want to take care of this ahead of time. You don't want to have to petition anything. You don't want to have to deal with the estate. You don't want to have to deal with you don't want to have to deal with having the courts name a beneficiary. You want to just do it right the first time. And even if you're of the mind that you're not really looking to make your kids rich, you just want to make sure you have enough money for you, and whatever's left is whatever's left, and they get to split whatever's left. That's fine, but the idea is there's going to be something left, whether it's $5 or $50,000 or $5 million. There's something going to be left. Hopefully hopefully you pass away before your money passes away.
Yeah.
And so there'll be something left, and so even though you may not want to make them rich, you don't want to make it unduly difficult for them to get it and make go through the courts and all the kind of stuff that probate deals with. When
you meet with somebody and you talk about various aspects of financial planning, bucket strategies and income and all that stuff, at some point, does the conversation swing toward things like beneficiaries and estates, even though you don't do estate planning because you're not an attorney. But does this come up? And if so, where do you generally look at? Just in general, what do you look at?
Well, generally, it depends on what the goals are. I mean, if somebody has said that we need control over assets, and part of the data gathering and part of the getting to know the client, we're getting to know them on a personal level, what their kids are like and things of that nature. And so if we find that, so-and-so's not, well, have you thought about, special needs trusts if they're disabled and things like that? But so we may broach the subject early on in the discussion because we need to steer the conversation that way. If it's just, we got 3 kids, they'll get whatever's left, they can do whatever they want with it, then usually the beneficiary titling issue doesn't come up until we're doing paperwork to open accounts.
In which case,
then it's a matter of, we need your names, beneficiaries, their social security numbers, their addresses, their date of births, to list the beneficiaries. because you've already said whatever's left they get, there's no strings attached.
So when you're doing financial planning, really it's, since you don't do the actual estate planning, you don't do the attorney work.
No.
It's more just the planning aspect, which is most of it is beneficiary related, right?
Most of what we as financial planning professionals are doing are coordinating the estate with the beneficiaries and things of that nature.
Have you ever run into an issue where the client will go to an estate planning attorney, and the estate planning attorney says do X, and they come back to you and say,
yeah,
the estate planning attorney says to do this.
Well, they'll get a trust done. Usually these are where they've got a deal for $400, or get your trust done for, and so the attorney's spending as little time as possible doing it, and there's nothing wrong with those if you're very straight vanilla forward, you don't have anything going on, but a lot of times we'll see it and say, well, now that you've got your trust, you need to change the title of everything into your trust. So we'll have somebody come to us and say,
everything in your trust.
Well, that's just a blanket statement. And so they'll come to us and say, we need to change the titling on everything. So we say, okay, here are the brokerage accounts. Oh, we need to change title on the IRAs too. No, you don't want to change the name on the IRAs, because you changed the title of the IRA from your name personally to your trust. You just created a taxable event of whatever's in that IRA.
Explain why very quickly.
Because a trust or an IRA can only be owned by, or the beneficiary has to be an individual. It can't be, you have to be, the owner of it has to be an individual. It can't be a trust. You change it to the trust, you're taking it out of the IRA.
And what does it become at that point?
It can be the exact same asset. So you have $300,000.
It's just a post-tax IRA?
It's just a post-tax account.
So
it changes it from a brokerage IRA to a brokerage account.
So it becomes your personal money.
Yeah, it's just your personal money, and it's all taxable, going from point A to point B. Or the other thing that's more common is, that one's pretty easy to get over, is change all the beneficiaries on everything to your trust.
This is what the estate planning attorney
sometimes
will
a blanket statement will be just change all the beneficiaries. They don't specify what beneficiaries, on what types of accounts. And again, it goes back to reality. I mean, it'll work. You name the trust. If your kids are the beneficiary of your trust, it'll work fine. It may work finer. It may work better to name the kids individually as the beneficiaries.
For the reasons you said a little while ago.
Because it just makes it a lot easier for them to be separated, to be able to have their own individual beneficiary IRAs, not be kind of tied to their siblings anymore. Yeah. You don't have to keep the trust open, and have a trustee take a distribution and then send the money out, do a trust tax return every year that you're doing distributions, because the trust is getting the 1099 and then it's doing the K-1s out to the individuals that receive the money to pass the taxation on. Just name if control is not an issue, just name the kids directly.
Very quickly, because we're
or the beneficiaries directly.
If an estate planning attorney says just go ahead and put everything in the trusts, which includes your IRAs and your 401ks and all that, how am I going to know? How would I know that it's a bad idea? I'm going to wind up with a tax bill for doing this.
Well, that's why hopefully you've got somebody that's helping you do the paperwork, and they're saying, wait a minute, are you sure that's what you wanted to do? So let's talk to your attorney and find out exactly what it is and why. And there may be some obscure, rare instance why that was the reason. I don't know. But I'd say let's just, before we just do everything, let's find out exactly why that they wanted this done, and whether maybe this was just, like I said, a general blanket statement and it didn't mean to cover IRAs, or maybe they're doing something very special that they wanted to do it this way.
So if you get advice from an estate planning attorney, it's best to go back and check with your advisor.
The estate planning attorney is not going to be changing the title on the forms.
You have to go to your advisor.
You got to go to your brokerage company, your advisor,
somebody. Well, the brokerage company's not going to. They probably will just say, "Oh, okay," because they're not planners.
No, they're not. But they play one. No, they don't play one on TV.
I just wonder, for somebody who's doing this themselves, how in the world are they supposed to know? My estate planning attorney told me to change the ownership of the IRA.
The only time I've ever seen this happen is with a low ball trust, which is not uncommon.
What's that?
Where you don't. It's a very low price, where you're almost doing it yourself. You're just having an attorney do the paperwork so you can.
Or you're having a website do it.
Or a website do it. And you're not getting really hands-on treatment from that attorney, because
estate planning attorneys may know that.
And I've never had the issue where they said it was a blanket statement and we questioned it, and they said, "Oh yeah, well that was for all your non-IRA assets."
Yeah.
And then,
I think you got to be careful when you do this, which is why it's a good idea to talk to your advisor.
But it's all about understanding what it is you're trying to accomplish. Going back to the puzzle, how do you want that puzzle to look? And let's put the pieces in place to make sure that that puzzle happens the way you want it.
So if control isn't an issue, but probate is, probably a good idea to have a trust. If
control is an issue, it's a great idea to have a trust.
Because that can really come in handy. You want to talk more about this stuff? Again, Professor, you don't actually do the work. This is estate planning attorney type stuff.
Right. We cannot do any legal work. We can just help you understand the options of things, that what happens if this, then that.
The ramifications.
Is that what you want?
The ramifications of what's going on.
And like I said, there's no problem. I mean, there's no real problem with naming a trust as a beneficiary. It can still accomplish the same goals. It's just, if control's not an issue, it may be a lot easier to do it a different way. Not easier for you necessarily, but easier for your heirs.
Yeah. Talk to Professor Plum, any of the Lucia Capital Group advisors, in fact. 800-644-1150. That's the number there, 800-644-1150. Talk about things like beneficiaries. It's important to understand not so much the ins and outs of it. That's what your advisor is there for, but at least understand the as Professor Plum said, the ramifications of if this, then that. Your advisor can help you to understand that and say, is this really what you want to have happen? If so, they can proceed, and if not, you have some options before you make it happen. Again, 800-644-1150. Professor Plum, thank you so much.
Anytime.
And we will next time I can find you free, which isn't all that often. Oh, was that today or was that last week? I forget. When did I talk about that? I think that was last time. That's right. I left a trail of popcorn.
You promised me popcorn again, and I'm not getting my popcorn again.
All right. I tell you what. I used to throw you a fish, but then you wouldn't make the clapping noise, so I had to stop that. I will have popcorn for you next week. How's that? Works for you?
Okay. Right. We'll see if it comes in this time.
It won't, because, as I said, what my promises mean, probably at least not to you. They don't mean anything. For Professor Rick Plum, certified financial planner professional, I'm Johnny Dean, host and moderator here, non-advisor, but still a fun kind of guy. Thank you very much. Make sure you subscribe to our podcast. Go to Spotify and subscribe, download, and do all that stuff. You won't miss a single solitary episode. We thank you all for listening, and we'll talk to you again next time.
The information provided should not be considered specific tax, legal, or investment advice and is not specific to any individual's personal circumstances. To the extent that this material concerns tax matters, it is not intended or written to be used and cannot be used by a taxpayer for the purpose of avoiding penalties that may be imposed by law. Each taxpayer should seek independent advice from a tax professional based on his or her individual circumstances. Different types of investments and/or investment strategies involve varying levels of risk, and there can be no assurance that any specific investment or investment strategy, including the investments purchased and/or investment strategies devised by LCG, will either be suitable or profitable for a client's or prospective client's portfolio. Thus, investments may result in a loss of principal. Accordingly, no client or prospective client should assume that the presentation or any component thereof serves as the receipt of or a substitute for personalized advice from LCG or from any other investment professional. You should always seek counsel of the appropriate advisor prior to making any investment decision. All investments are subject to risk, including the loss of principal. This material was gathered from sources believed to be reliable. However, its accuracy cannot be guaranteed. The information provided is based on current laws, which are subject to change at any time. Lucia Capital Group is not affiliated with or endorsed by the Social Security Administration or any government agency. Social Security rules can be complex. For more information about Social Security benefits, visit the SSA website at ssa.gov or call 800-772-1213 to speak with an SSA representative. Annuities are long-term investment products designed for retirement purposes. Guarantees are based on the claims-paying ability of the issuer, subject to their terms and conditions. Early withdrawals may be subject to surrender penalties and, if taken prior to age 59.5, may be subject to an additional 10% federal tax. Annuities are not FDIC insured. Certain terms and conditions apply, so please read insurance company materials carefully. Insurance services offered through LPL Financial or its licensed affiliates. California Insurance License Number 0518721. IRA withdrawals will be taxed at ordinary income rates. Withdrawals prior to age 59.5 may also be subject to a 10% penalty tax. Examples cited are hypothetical, are for illustrative purposes only, are not guaranteed, and subject to potential federal and state law amendments. There is no guarantee that you will achieve the results discussed or illustrated. Rick Plum is a registered representative with and securities and advisory services offered through LPL Financial, a registered investment advisor, and member FINRA SIPC. The investment professionals are affiliated with LPL Financial and are conducting business using the name Lucia Capital Group, a separate entity from LPL Financial.